Hi, everyone. Welcome to the 12th episode of CryptoScam, and the one that I believe will be the greatest one of them all. This is a crypto scam about crypto scam lawyers, or more specifically, the lawyers of crypto scam tokens is what I actually meant to say. And a bit of a backstory here. This has been the absolute week for cease and desist letters and bounties and crazy legal action. And I have to say, I had a very interesting situation that happened to me. And I am going to try to jump right into it. There's not going to be much BS. We have so much that we need to cover that got to be a little bit, I also have to be a little bit careful here. Let's try not to get into any extra legal action. So let's just go ahead and do screen share once again, somewhat carefully, and work our way from there. So as mentioned on our Bitcoin briefs, this has been a rough week for the Bitcoin faithfuls. It began with Hodlnut, and I cannot pronounce that, with a bounty by Craig Wright that caused them to leave the internet, leading to a legal campaign for him. We will find out if I will actually need one. Then it was Peter McCormick's turn to get involved in this crazy mess when he got a defamation suit from Craig Wright, known as Fake Satoshi, along with Kelvin Ayre. So Peter McCormick immediately, the same day, published the letter. It doesn't say cease and desist on his letter, unlike my letter, which I will share with you, just like Peter McCormick did. And if you read over this letter, it basically accuses him of calling Craig Wright Fake Satoshi and is seeking legal action unless he apologizes and so on and so on. Please read it. Now, Peter McCormick then went on and published his official reply to that letter, which we will find out if this is actually advisable from his legal counsel. Now, of course, us hardcore Bitcoiners don't really like listening to legal counsel. Ironically, there is a law show on this channel, and but I am, however, going to try to be a little more careful and not get myself into any additional legal action. So that's the little backdrop. Peter McCormick got his letter on April 12th and published it the same day. I got my letter on April 10th. Now, I got that letter in my email box. I did not actually get the letter itself. You will know why in a bit. So I'm going to flip screen share. Let's go ahead and read the letter that I got, and then we will see where this podcast goes. I'm going to stop screen share for a second. I'm going to make sure I share the right thing. What am I sharing here? Show all windows. This one. Again, very, very careful. I'm keeping an eye on the live stream, making sure that I am sharing the right stuff. Let me see, make sure it's being shared. And here we go. Okay, let's read the letter that I got. This was very interesting. The letter is dated April 10th. And I did blank out the name and address that the letter was sent to. And more on that in a little bit. There's no reason to dox myself or anyone else, especially anyone else. And on top it says notice to cease and desist for internet defamation by SG Law Group. Let's go ahead and read it. Dear Mr. Vase, please be advised that our law firm has been retained by TokenPay to investigate and take legal action against you for the unwarranted and defamatory attacks against it made by you online, specifically a video posting made by you on April 2nd, 2019 to youtube.com. I actually do so many videos. I don't remember what I did on April 2nd. TokenPay is an international company that, among other things, trades in the cryptocurrency market. Our client provides its members with access to an innovative market utilizing advanced technology. Let me read that. Our client provides its members with access to an innovative market utilizing advanced technology and providing a high level of customer service. TokenPay, yeah, no, I know it's laughable, but let's just read on. It took me a second to process what I just read, and I'm like, right. TokenPay has established a well-founded international reputation, I'm sorry, guys, for the quality of its services and customer satisfaction, clearly not. And your unlawful action and baseless accusations have damaged that reputation and adversely affected our client's business. Ooh, I actually kind of hope so, but that's personal opinion. Maybe I shouldn't have said that. You have personally posted willfully false, misleading comments about our client. Examples of your defamatory statements include, let's look at the scammiest of all scams, right? Let's look at TPAY, youtube.com. TokenPay is one of the scammiest projects that has ever existed, youtube.com. TokenPay might be the scam of 2019 or 2018, right? youtube.com. At least people know that TokenPay is a scam, youtube.com. Trying to think of other major scams. That one's like the worst. Though this one doesn't actually reference TokenPay, but okay, youtube.com. And one of the biggest scams in the space, youtube.com. Okay. Let's keep reading, guys. This actually gets way more interesting. No, I wish they included the dates, guys. I really do. I'm looking at your live chat. I shouldn't be doing these live because I get distracted. But those are great quotes. Thank you very much, Walter. And no, I really wish they included the dates. I could have replayed them for you. Okay, let's move on. The above statements made in reference to TokenPay are utterly false, without merit, and they are defamatory per se, in that they depict our client as engaging in fraudulent activity that violates civil and criminal law. New York law defines defamation as a statement, open quote, which tends to expose a person to hatred, contempt, or aversion, or to induce an evil or unsavory opinion in the mind of a substantial number of people in the community. That is from the Mencher versus Chasley, 297 in New York, 9475, and E2D257 from 1947. Statements that tend to injure another in his or her trade, business, profession will be considered defamatory per se. That is from Lieberman versus Goldstein, 80 New York, 2nd District, 429, 435, 605, and E 2nd District, 344. A bunch of other numbers, 1992. I'm sure people can find it. Just Google Lieberman versus Goldstein. Expanding upon injurious statements made to another's trade, business, or profession, a New York court stated, defamation per se will occur when words affect a person, open quote, in his profession, trade, or business by imputing to him any kind of fraud, dishonesty, misconduct, incapacity, unfitness, or want of any necessary qualifications in the exercise thereof. That is from the 34th New York jury, Liberal versus Slander, from the 4-Star Lighting Inc. versus Merrick from 1977. Okay, one more. A New York court found that an anonymous internet blog stating the plaintiffs engaged in an illegal scam was in fact defamatory, and ordered the internet service provider, ISP, to disclose the identity of the anonymous internet poster. That is Ottinger versus non-party, the Journal News from 2008. Something, in the internet era, at least. So go ahead and Google those. All right, let's move on. Your attempts to spread slanderous and defamatory material about our client have caused serious and irreparable injury to it, its reputation, and its business. Our client will not stand by and allow this unlawful conduct to continue. We hereby demand that you immediately remove all defamatory and disparaging remarks, whether spoken or written, regarding our client made by you. Immediately cease and desist in publishing defamatory statements about our client, whether the statements are made by you or a third party. I really probably should have had this close to my camera so I can look at the camera and read. Let me do that. All right. Yeah, that would have made so much more sense. Publicly issue a retraction and formal apology for your unwarranted defamatory statements about our client, and compensate our client for its attorney fees and costs. Please note that this law firm does not attempt to restrict legitimate free speech, and we believe that the internet is an important medium for dissemination of accurate and truthful information and for fair comment on issues of interest. Your activities, however, unlawfully encroach upon our client's rights. You guys are still seeing this, right? Yeah, I think so. Oops, let me slide this over a little bit. This letter, hold on, something's wrong. Maybe you guys weren't seeing it. This letter puts you on notice that should you refuse to comply with our demands by April 15, 2019. This is why it was so critical for me to do this today. And unfortunately, I'm actually not ready. There was so much more work that needed to be done because being in a different place this weekend, and today being Monday and tax day, it was really, really difficult. But I did my best, guys, to bring this to you today because the letter was dated April 10th. I didn't even see it till April 12th. And I wish I had more time. This letter puts you on notice that should you refuse to comply with our demands by April 15th, 2019, today, we will have no choice but to recommend that our client pursue all legal causes of action, including the filing of a lawsuit to protect its interest. We will pursue both damages and attorney's fees and costs incurred by our client as a result of your actions. This is a very serious matter that requires your immediate attention. Well, you guys got it. We therefore strongly recommend that you contact us immediately to address and resolve this situation. This letter is your one and only chance to resolve this matter amicably. I have to, 1 second here. I have to, I got to highlight something. Please be aware that this letter is copyrighted by our law firm, and you are not authorized to republish this in any manner. Use of this letter in a posting in full or in part will subject you to further legal causes of action. The foregoing is not intended to be a complete recitation of all applicable law and/or facts and shall not be deemed to constitute a waiver or relinquishment of any of the TokenPay's rights or remedies, whether legal or equitable, all of which are hereby expressly resolved, including TokenPay's right to all available remedies against you, including but not limited to the recovery costs of the attorney's fees. So like this letter seems to really, really emphasize the fact that this guy really wants to get his attorney fees. Well, we'll see how that goes in a second. So very truly yours, Sean Garcia. Mr. Garcia, let's have some fun. the tone-based way. What other way is there? Hope you guys enjoyed that. Minimize that. Let's change screen share. Let us change screen share back to, gotta be careful here, of lawyers watching. Back to this. Now, of course, I did say other things. I mean, like, sure, I said all kinds of things on YouTube. For more information, please, and I'll put some of these links in the video description after. I just didn't have the time. Please check out the Bitcoinist article. Thank you, Wilma Wu. Wilma Wu published my tweets from a while back on TokenPay, where I decided to do a little bit of investigative journalism. And I found a few things. Now, the tweet that I was actually looking for, it was hard for me to Google these, right? So let's click on one of these bad boys. And because I'm looking for one specific tweet in this. And I think it was this one. No. This one. So check that out. I have a link in there. It's about the bounty program. This is not me calling them a scam. This is somebody else calling them a scam. TokenPay scammed $1 million from bounty and referral program. So please check it out. Lots of interesting stuff here. I did this a while back. I did this in July of 2018. It's been almost a year. Please check out this tweet storm on TokenPay. I'll put this article in the video description. There were other tweets. They only cherry picked like 4 out of the 8, unfortunately, but there are all 8. Okay, let's now head on over to the TokenPay's website. On the TokenPay's website, if you go into their team section, which is somewhere right there, company team, we can take a look at their team members, most of whom are not really important to me at the moment, except Mr. Sean Garcia happens to be the general counsel of TokenPay. Public information. We're dealing with all public information here. That's how we do it on the tone-based channel. Now, heading on over to Mr. Sean Garcia's law firm, I see the initials as G, so I can only assume that Mr. Sean Garcia is basically it's his law firm, unless it's a giant coincidence that SG law firm happens to have Sean Garcia's initials. He's also the one of 2 attorneys listed on the site. So let's just read the public information available on SGR. S Garcia. Sorry, I'm a little slow. sgarcialaw.com. As an experienced attorney based in Miami, Mr. Garcia has gained valuable knowledge in corporate law, real estate, property insurance, and estate planning matters. Representing clients as a senior partner for more than 6 years at SG Group. In addition to his work at SG Group, Mr. Garcia has also contributed his time to the following organizations and in the matters of a bunch of other stuff. Okay. Now we know the background and expertise of Mr. Garcia. Corporate law, which is kind of general, real estate, property insurance, and estate planning. All right. Now, there's a couple of ways we can go from here, and I haven't yet decided which way to go. So I have thought about a reply to Mr. Garcia, which I jotted down a couple of notes on a napkin, which I want to share with you guys. And I'm sure everyone at TokenPay and Verge and Litecoin and everybody else associated with Team TokenPay. We have Verge, we have Litecoin Foundation, Miss Elizabeth Retos, not familiar with her work, and a couple of other people. These are their advisors and who they are working with. And I'm sure they are all watching along with SG Law Group. I hope all of those attorneys are also watching. If not, I'm sure they will. Now, so where do we go from here? Do we investigate the law cases that they are referencing? Or maybe we can do that a little bit later because I don't want to lose my audience. So let me just give a few comments I'm going to stop the screen share. And I'm just going to, say a few things about not necessarily mine, but an opinion of the letter that was sent, that was supposed to be sent to TokenPay. More on that in a minute. All right, let's give this a shot. Dear Mr. Garcia, in response to your claim of defamation and libel against your client TokenPay, it is fully understandable why your client has resorted to such intimidation tactics rather than address the criticism publicly. By sending this letter, you open your client and your firm up to heightened scrutiny. In addition to the meritless legal assertions, which will be addressed below, or which will be addressed later, this particular cease and desist letter appears to be plagiarized from a 2007 letter written by the Dozier Internet Law PC. Oh, more on that later, kids. Oh, that is the gem. The entire letter that I got, maybe not in its entirety, 80% of that letter was plagiarized, word for word, from a 2007 letter by a different law firm. Oh, I'll show it to you. We're getting there. In your letter, you claim to use the word scam in relation to TokenPay, the company, and its token TPAY on YouTube.com defames your client. But words like scam are statements of rhetorical opinion that do not support a claim of defamation. Please go Google Mccabe versus Rutner, 814 F.2D 839 842 First Circuit 1987. That court decision relied on the doctrine of constitutional protected opinion, which was an attempt to reconcile the conflict between defamation law and the First Amendment by the Supreme Court. The Supreme Court relied on the ruling from Gertz versus Robert Welch, 418 U.S. 323 339-40 from 1974, which had to make a distinction between opinion and false statements of fact. The Supreme Court stated, under the First Amendment, there's no such thing as a false idea. However, pernicious, I'm quoting the Supreme Court here, I have to write this down. However, pernicious an opinion may seem, we depend on its correction, not on the conscience of judges and juries, but on the competition of other ideas. But there is no constitutional value in false statements of fact. Neither the intentional lie nor the careless error mentally advances society's interest in uninhibited, robust, and wide open debate on public issues. Sorry, that was a little bit hard to read, but Supreme Court. As the general counsel of TokenPay, you may not agree, but expressing an opinion with the word scam seems to be a fair characterization of the TPAY token to those that fully understand the functions of a blockchain and the ICO landscape. Of course, your client denies ever having an ICO, but instead publicly admits to bartering, which in reality is just selling, a coin that has no value. Also in quotes, and you'll see why in a minute, for a highly valued commodity known as Bitcoin. Let me read that, guys. As the general counsel of TokenPay, you may not agree, but expressing an opinion with the word scam seems to be fair characterization of the TPAY token to those that fully understand the functions of a blockchain and the ICO landscape. Of course, your client denies ever having an ICO, but instead publicly admits to bartering a coin that has no value for a highly valued commodity known as Bitcoin. Now, let me pull that up. Shout out Tour de Meester for bringing this to my attention, because I follow Tour de Meester and Nick Carter, and this showed up, but I do not follow TokenPay. So here it is, where TokenPay states, we never conducted, oh, wait, screen share. My bad. It's coming. Again, careful here. Boom. Tour. Thank you, Tour. Now, stated by TokenPay, we never conducted an ICO, close in quotes. We bartered our unique blockchain coins called TPAY for ones called BTC. Nowhere will you find any suggestion if an implied investment or offering of any sort. In fact, every single page on the white paper and website states that the coin has no value, to which Tour replied, why would you sell something you claim has no value? Okay, this discussion goes on, and we will get to that in a minute. Okay, so let's see what else I've scribbled down. It will be interesting to find out why your client decided to accept Enthusiast's Bitcoin. Initially, they're not really investors. They're not a security. So enthusiasts, that's a good word. It's a good word. It will be interesting to find out why your client decided to accept Enthusiast's Bitcoin in exchange for a token of no value. But we will need to wait for a civil or a criminal investigation by the authorities and or regulators. For now, we can simply point out the fact that TokenPay did, in fact, refer to their token sale as an ICO, but then deleted the evidence. Where is this evidence? It's in the same Twitter feed, and it is right there. Thank you, Shillhouse. I owe you a beer, my man. Boom. Countdown, just 7 days to TokenPay coin sale, as tweeted out by TokenPay. Register now at tokenpay.com. 100% bonus run December 7th to 13. Hashtag Bitcoin, hashtag cryptocurrency, hashtag token sale, hashtag ICO. Okay, nice. Now we're getting somewhere. All right, let's move on. At the start, TokenPay was looking to sell 57% of the 25 million total supply of TPAY, created out of thin air, of no value, as stated by, well, TokenPay themselves. They stated it just last month. Currently, there are over 15 million tokens in circulation. Okay, so right here is a Medium post from TokenPay. Boom, and you can see all the numbers. 14.250 million tokens went to the token sale. 2.5 million went to the founders. It could just be one person. I have no idea how many founders there were. I didn't have time to do that research. You guys can do it yourself. No idea how many founders there were. An additional 750,000 tokens went for marketing, bounties, and advisors. An additional 1.25 billion tokens went to team and developers. There are some lockups. I think the lockup period is over. When was this published? November 8, 2017. Oh God, the lockup period is way over. That explains why there is more than 15 million coins out in circulation. And remember, they have just stated that this coin has no value. But if it has no value, why is 750,000 tokens being reserved for marketing, bounties, advisors, and paying team members? Okay, awesome. Love it. All right, you can read about it here. All the numbers are there. The internet never forgets, kids. Just like that 2007 lawyer letter that was plagiarized by Mr. Garcia. I can't wait to get into that in a few minutes. Let's just finish up on my random and general thoughts. Any blockchain professional should recognize, let me put that on the screen for you guys, just so it's there for a little while. Any blockchain professional should recognize that the TPAY tokens do not have any necessary utility for the company other than fundraising. Based on these facts, just the simple facts that I listed, God knows what cockroaches you're going to discover when you actually start doing some research. Based on just these three little facts, questioning the intentions of TokenPay or referring to it as a scam is obviously an opinion, unless you have sufficient evidence that this opinion is stated based on falsely created facts by the person making the said opinion. And speaking of facts, considering the fact that your letter was plagiarized, it is no surprise that it was also addressed incorrectly. You also failed to investigate whether or not the recipient of your letter is a resident of New York State, which happens to be all the case law that you mentioned. And we will see how binding or useful that is. The cases you use to support your claim that engage in defamation and libel bear very little nexus to the facts at hand. As it turns out, one of your court cases, the only one in the internet era, of Ottinger versus non-party The Journal News, proves that the defendant will very likely get this charge dismissed, just like in the case you listed. This case also explains how these types of tactics, along with identifying anonymous internet bloggers, are used by those with money and power to intimidate common citizens that use the First Amendment right of free speech. But the worst thing about your letter, is the following. I have to read. I'm reading from their letter. Please be aware that this letter is copyrighted by our law firm. I almost want to pull it back up. I'll pull it back up in a minute. Please be aware that this letter is copyrighted by our law firm, and you are not authorized to republish this in any manner. Use of this letter in a posting in full or in part will subject you to further legal causes of action. Yes, I will publish this letter on Twitter the moment we are done with this episode of CryptoScam. Given that the statement, along with most of your letter, was plagiarized word for word from a 2007 letter by another law firm, and that this letter does not seem to be registered at www.copyright.gov, which would be very difficult for you to copyright considering it was plagiarized, your intimidation tactic is being challenged by publicly disclosing your letter. Hopefully your firm will no longer be successful at this practice, as it has now been challenged in bringing a non-existent copyright claim. In conclusion, a little conclusion, this is a meritless, frivolous lawsuit. Should you actually file a complaint, we are looking forward to the discovery phase as part of the defense, where all parties associated with TokenPay will most likely need to disclose public keys of TPAY tokens and the BTC tokens that they sold them for, and other pseudo-anonymous cryptocurrencies received. As if we go back to the TokenPay website, you, Mr. Garcia, is right there as a general counsel of TokenPay. And considering that 2 million 2 million TPAY tokens were allocated for marketing bounties advisors and other team members, it's very likely that you, Mr. Garcia, have received a bunch of TPAY tokens. So you will potentially be subject of this discovery of where the token pays went. and how useful they actually are. So there you go. These are my thoughts on your letter. Feel free to advise your client that if he wants to continue filing legal action, to do so, but please make sure you address your next letter to the right recipient at the right address. So you may want to do a little more investigation than you did in where you plagiarized that letter from. So let's take a look at how the letter is plagiarized. Oh, that is certainly true, Jesse. If I was rich, I would certainly have my lawyer reply to it. But I still will have my lawyer reply to it. However, because my job is a content creator, and this was the greatest content I have ever received in a long time. So let's now take a look at the two letters side by side. Let's stop the screen share. And once again, be extra careful. You know what? Let's be extra careful. And too many windows. Boom. Here it is. What if I move it to the other? Oh, no. Well, it's all right. Leave it here. Let's not screw up. Boom. Let's put it side by side and read the letter from Mr. Garcia one more time. Please be advised that our law firm has been, I know I'm gonna do this. Let's use orange for the color of Bitcoin. Hope you guys can see this. Make it a little bigger for you. Oh, wait. Messed up. Hold on. Box. Boom. Highlight this right there. And let's read. God, I hate reading. Right there. You know what? What if No, I'll just leave it here. Please be advised that our law firm has been retained by TokenPay to investigate and take legal action against you for unwarranted and defamatory attacks against it made by you online. Specifically, a video, well, that's details on Mr. Base. Let's go to 2007. Please be advised that our law firm has been retained by Direct Buy Inc. to investigate and take legal action against you for the series of unwarranted and defamatory attacks against it made by you on your visitors to your various websites. Next. TokenPay is an international company. Yeah, our client provides its members what that's specific to TokenPay. TokenPay has established a well-founded international reputation for the quality of its services and customer satisfaction, and your unlawful actions and baseless accusations have damaged that reputation and adversely affected our client's business. Direct Buy has established a well-founded reputation for the quality of its services and customer satisfaction, and your unwarranted action and baseless accusations have damaged that reputation and adversely affected our client's business. You have personally posted willfully false and misleading comments about our client. Examples of your defamatory statements include, let's go to 2007. You have personally posted many willfully false and misleading comments about our client. Examples of your defamatory statements include, of course, the statements are going to be different. Let's drop down a little bit. Let's move on. Moving on. The above statements made in reference to TokenPay are utterly false, without merit, and they are defamation per se, in that they depict our client as engaging in fraudulent activity and violates civil and criminal law. Let's go to 2007. The above statements made in reference to Direct Buy Inc. are utterly false and without merit, and they are defamatory per se, and that they depict our client as engaging in fraudulent activity that violates civil and criminal law. Man, you can at least change a comma here and there. I'm really not reading your comments, guys. I know, everyone's telling me to get a lawyer. It's more fun. All right. But then obviously the law cases are going to be different. So let's go to the other side of it. Boom. Let's look at Mr. Garcia's letter. Your attempt to spread slanderous and defamatory material about our client have caused serious and reputable injury to it, its reputation, and its business. Our client will not stand by and allow this unlawful conduct to continue. 2007. Your attempt to spread libelous and defamatory material about our client have caused serious and irreparable injury to it, its reputation, and its business. Our client will not stand by and allow this misconduct to continue. We hereby demand that you immediately remove all defamatory and disparaging remarks, whether spoken or written, regarding our client made by you. Well, immediately remove all websites. These are a little different. This one, the number 2 looks the same. That's okay. I'm reading too much. Look, the next 2 paragraphs are identical. I don't need to read them all. Look, you can't deny that this is plagiarism, right? Like, they even bolded the same letters, for God's sakes. Like you can't go more copy paste than this. It's amazing. Amazing. Right? You're supposed to be a lawyer. And of course, the best part. They're all the same. Like all 4 of these paragraphs are the same. Please be aware that this letter is copyrighted by our law firm, and you are not authorized to republish this in any manner. The use of this letter in a posting in full or in part will subject you to further legal causes of action. That was written in the 2007 letter as well. And guess what? It didn't work then either, because that's how it is on the internet. All right. Where we go next? Let's take a look at the court cases that were listed in this. Let's get rid of some of these here. Boom. Let's take a look at the court law from New York State between 1944, 47, sorry, and 2008. Now you guys might think this is the boring part, but I assure you it's not, right? If you are a podcaster, especially if you are a podcaster, you may be dealing with this. So you really want to stick around for this next part. If you are not a podcaster, but you have a favorite podcaster, you may want to stick around for this part so you can remind them of their rights the next time some law firm wants to throw around insane accusations. Okay, so let's go take a look. All right, I'm going to stop the screen share again. I'm going to get rid of that. So where are we going to next? So right here. Okay, so I made a few notes. I'm going to share this. Word document. So there were 4 court cases that were used in that law case. So let's look at the very first one. We're going to look at them in order, with the last one being the most interesting, of course. Mencher versus Chasley from 1947. What was that court case all about? In August 1944, following his dismissal as chairman of the War, Price, and Rationing Board for the borough of the Bronx. Oh, actually, hold on a second. What if I move it here? Oh, I paused the thing. Okay, you know what? Give me a second here. I can't screw this up. Even I can't screw this up. Stop share. Boom. And let's share again. All right, here we go. In August 1944, following his dismissal as chairman of the War, Peace, and Rationing Board of the Borough of the Bronx, the defendant issued a statement to the press in the course of which he made certain remarks about the plaintiff, who was then in charge of the Information Division of the Regional Office of Price Administration. Claiming the statement falsely charged him with 1, being a communist, having communist affiliations and sympathies, and 2, having improperly and unfaithfully performed his official duties. Plaintiff sues for libel. Okay, so basically one guy, one former government official accused another former government official of being a communist and misusing public office. Okay, that was the case. While the present case, while in the present case, there was no direct charge that the plaintiff was a communist or had communist affiliations or that he had misused his public office, the statement read against the backdrop of its issuance under the circumstances of its publication, it's certainly susceptible to such a construction. As to the first, the assertion that the plaintiff had formerly been employed by the Daily Worker, generally known to be an official publication of the Communist Party, and that he had acted as a campaign manager for a communist seeking public office may reasonably be understood as a charge that the plaintiff was either a communist or that he cooperated in communistic activities associated with the communist figures. And as to the second aspect of the statement, in reciting the plaintiff had been involved in the effort to remove defendant from public office because he, the defendant, had opposed certain units of political personnel group. So this was a very specific case. Now, one last comment on this case. A writing is, and this was the part that was quoted in the letter to me. A writing is defamatory that is actionable without allegations or proof of special damages. If it tends to expose a person to hatred, contempt, or aversion, or induce an evil or unsavory opinion of him in the minds of the substantial number of the community, even though it may impute no moral turpitude to him. But that is from a different case. That is from Catapodis versus Brooklyn Spectator. Okay, so while this statement is in this court case, that wasn't in the court case. So again, I'm not a lawyer, just trying to read case law. I have no idea how you people do it. I have no idea how you lawyers do it. Just give you some back. I mean, like, I don't know how this case turned out. It's from 1947. I don't have the, I don't know how that one won or not, but we'll get to that in a second. Let's look at case number 2. Lieberman versus Goldstein. Lieberman, the plaintiff, brought a slander claim against Goldstein, the defendant. One cause of action alleges that Goldstein, a member of the tenant's board of directors, told a fellow board member that Lieberman, their landlord, bribes police officers so as to not to receive parking tickets. Goldstein admitted that he did not know whether this allegation was true, but argued that the statement was protected under the common interest qualified privilege because it was made between 2 members of the board of directors in an attempt to discover whether the allegation was true. The trial court dismissed this case of action. It was dismissed, finding that the statement to be qualified privileged and that Lieberman had failed to raise an issue of malice. Another cause of action alleges that Goldstein told a building employee that Lieberman threw a punch at him, screamed at his wife and daughter, called his daughter a slut, and threatened to kill him and his family. The trial court dismissed this case of action as well, finding that the context of the parties' history of conflict, that the statement was simply rhetorical hyperbole. The appellate division affirmed, Lieberman appealed. Okay, so the second case that was presented in this letter was basically dismissed in court. We have two more, just two more, guys. Two more, and then I'll let you go. But like, man, this I basically didn't sleep for a night or two trying to read through this stuff, man. Like I learned a lot. 4-Star Stage Lighting Inc. versus Merrick. The first and second causes allege inter alia, I don't know what that means, that defendants used the order of seizure in order to force the plaintiff into buying defendant Merrick's equipment at an unreasonable price. This allegation is sufficient to plead materious causes for abuse of process, since it suggests that the defendant were using the order of seizure for an improper purpose. Not yet sure what this has to do with defamation. Subdivision 1 of Section 487, I guess the judgment of the judiciary law provides that an attorney is guilty of a misdemeanor and must pay treble damages in a civil action if he should deceive the court. To the extent that the third cause alleges that the defendant Aslan deceived Justice Tyler by substituting a page in defendant Merrick's affidavit, it states a valid basis for relief. It is the general rule that words not actionable in themselves may become so by being spoken of persons engaged in particular profession. Thus, words are libelous if they affect a person in his profession, trade, or business by imputing to him any kind of fraud, dishonesty, misconduct, incapacity, unfitness, or want of any necessary qualifications in the exercise thereof. Right, that was the quote that was used in the letter to Tone Vase. Defendant Aslan's letter to Mr. Papp would tend to indicate that the plaintiff were not entirely honest, since they were in the process of leasing equipment, which they had no right to do. Hence, the fourth and fifth causes state viable grounds for recovery based upon libel. This is incredibly different. I don't know if you guys followed that. I read it a few dozen times, so I was able to follow it. Now, I do have to address a comment that just showed up. Someone is saying that I am obsessed with TPAY. They are the ones that are suing me. Or not yet. It depends who the lawyer is going to be next week. Okay, so the whole thing relies around Judiciary Law 487. Okay, let's just take a quick look at the Judiciary Law 487. I know this might be boring to you guys. The next one is really permanent to bloggers. Judiciary Law 487 provides, among other things, that an attorney who is guilty of any deceit or collusion or consents to any deceit or collusion with intent to deceive the court or any party forfeits the party's injured treble damages to be recovered in civil action. A plaintiff may bring an action to recover damages for attorney's deceit, regardless of whether the attorney's deceit was successful. Further, the plaintiff in a Section 487 cause may recover the legal expenses incurred as an approximate result of the material misrepresentation in a prior action. This whole thing revolves around an attorney being deceitful within a court. The language of Section 487 supports this conclusion because that section does not require that the claim be asserted in the same action in which the violation occurred. Rather, the section simply provides that an attorney who has practiced the deception will be liable for treble damages to be recovered in civil action. Okay, and that is from 4-Star Light versus Merrick. Okay, holding that Section 487 claim brought in a second action should survive a motion to dismiss because it was adequately pleaded. Okay, so completely unrelated to calling a token a scam. Now, let's stop the screen share. All right, guys. I know I'm keeping you here through case law, right? But this is what you will have to do if you end up getting a letter for defamation or libel or accusing you of some insanity. Okay? Let's look at the other case. The last one, and that is a gem. This is really, really interesting. I really enjoyed this one. This is in the matter of Ottinger versus non-party journal news. So this was the 2008 case that actually is really important if you're a blogger. If you're a blogger, and since this is a US case, it only kind of applies to the US. Let's review. You know what? Maybe I can make it bigger for the screen. Hold on a second here. Make it a little bit bigger. 125. There we go. There you go, guys. Okay. Man, that's a lot of reading today. And I'm only down to 600 viewers. Hey, it's important to me. Not as important as price to you. But let's see how much additional legal action I'm going to bring to myself, as all of you commenters are quick to point out. Let's check this out. With the explosive proliferation of online blogs and message boards, the ability to post anonymously has triggered a new breed of defamation lawsuits targeting many different people with the same name, John Doe. While the First Amendment has long protected the anonymous speaker's right to free speech, that protection may not be as robust when the speaker is accused of defamation online. Indeed, the anonymous John Doe, who identifies himself by a screen name or by no name at all, may be anonymous in an online may not be anonymous in an online defamation case. Although a plaintiff must still convince a judge to force the host of the website that carries allegation defamation material to unmask the anonymous poster, courts across the country have only just begun to consider what standard to apply before ordering such a disclosure. The decision is challenging because the standard must protect an anonymous speaker's right to free speech on the internet, while at the same time ensuring that parties injured by the defamation have access to an adequate remedy. In the Ottinger versus non-party the journal news, the Supreme Court of New York, Westchester County, adopted a standard to apply when deciding whether to compel a web host to identify an anonymous individual accused of posting defamatory statements on an online blog. Noting the lack of precedent on this issue, the Ottinger court adopted a test from a neighboring jurisdiction. The test first requires that the plaintiff to make a prima facie showing of each element of libel, and then requires the court to balance the defendant's First Amendment right of anonymous free speech against the strength of the prima facie case presented. While the test adopted in the Ottinger is more deferential, to anonymous speakers than previous tests of its kind in the Oninger court added a problematic caveat for when, as here, the test is applied to case involving a libel plaintiff who is a public figure. To unveil on a libel claim, a public figure libel plaintiff must prove an additional element of actual malice. However, the Oninger court explicitly held that evidence of actual malice is not necessary for a public figure libel plaintiff to unmask an anonymous poster's identity. This is a critical error because merely obtaining the identity of an anonymous critic is a form of remedy in itself for public figure libel plaintiff who may seek only to harass or intimidate their anonymous critic into silence. This case comment contends that by not requiring public figures libel plaintiffs to show actual malice to unmask anonymous online critics, the Oninger test contravenes established First Amendment precedent and applied will chill anonymous free speech online. So as you can see, the Oninger case was actually very, very critical to online blogging and anonymous comments, but specifically to anonymous comments. Now, as I read this whole document, guys, it is absolutely fascinating. I tried highlighting as least I could, but this shit was really good. So I'm gonna read a couple of more. I want this to be, I want other bloggers and YouTubers to be aware of this. And if you comment online, you should also be aware of this. The Ottingers ultimately received a building okay, so so I skipped what the case was about. So the Ottingers were, they were in formerly of public office, and they wanted to do a bunch of reconstruction on their house, and they got the permits. The Ottingers ultimately received a building permit and began construction. In September 2007, the Ottingers building permit became the topic of discussion on the LouHud.com blog, hosted by the Journal News, a newspaper serving Westchester, Rockland, and Putnam counties. Several anonymous statements appeared on LouHud.com blog, accusing the Ottingers of bribery, fraud, and deceit in connection with their receipt of the various permits and approvals necessary to renovate their home. The postings excerpted below as they appeared on the Ottingers complaint came from 3 screen names. This one, hid, and that one. It doesn't matter, right? And you can read the statements, right? That doesn't matter. I'll put the links in the description. In their complaint filed on February 5th, 2008, the Ottingers alleged that the preceding statements constituted libel per se and had the tendency to expose the Ottingers to public hatred, contempt, ridicule, and disgrace. The complaint named as defendants John Doe and Jane Doe, the Ottingers alleged that the anonymous persons making these statements knew them to be false or acted in reckless disregard of their truth or falsity. Further, the Ottingers alleged that the statements caused them to suffer damage to their reputational standing in the community. The Ottingers demanded a judgment in the amount of $500,000 for their claim of libel per se and $1 million in punitive damages. They also demanded the public apology be posted to the LouHud.com blog. To ascertain the identities of the defendant, the Ottingers served a subpoena to the Journal News on February 28, 2008. On March 21st, 2008, the Journal News moved to squash the subpoena pursuant to CPLR Section 2304. On April 11, 2008, the Ottingers cross-moved to compel. Anyway, the Ottingers won. On May 28, 2008, the court held a hearing regarding the motion and ordered the hearing conveyed special privileges to allow the Ottingers to seek pre-action disclosure, yada, 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 yada. No one appeared. And basically, the court ordered the Journal News to disclose to petitioners such information. Basically, the anonymous people were identified. Okay, the court ordered the Journal News to identify the anonymous bloggers. the Oranger's court adopted the dendrite test in full, which is another court decision similar to this decision, which was used in this case. However, since the dendrite involved a corporate plaintiff, the dendrite court did not address whether its third prong, which requires a prima facie showing of each element of libel, also includes the extra element of actual malice. That is the required showing for a public figure libel plaintiff. A claim of defamation involves injury to a person's reputation, either by oral extension, slander, or by written expression, libel. In New York, a libel plaintiff must prove a false and defamatory statement of fact regarding the plaintiff, which is punishable, published to a third party, and which results in injury to the plaintiff. But since the landmark decision in the New York Times versus Sullivan, the Supreme Court has also required that, that state libel laws differentiate between public figure plaintiffs and private citizen plaintiffs. Recognizing that the value of open discussion about the character and qualifications of public officials outweighing the potential of injury to the reputation of the individual, the Supreme Court requires public figure plaintiffs to prove the additional element of actual malice in order to prevail on the libel claim. A statement evidence, actual malice when it's made. All right, let me skip this part. Maybe I might have highlighted a little too much. Okay, here's the end result. This is a long document, guys. I did the best I could. By following Dendrite and Cahill, which both refer to unmasked John Doe defendants, the Ottinger court should have squashed the Ottinger subpoena instead of forcing the Journal News to unmask the anonymous posters accused of defaming the former congressman and his wife. The test established by Ottinger is problematic because it fails to incorporate any distinction between public figures and libel plaintiffs and private libel plaintiffs. The resulting precedent creates an end run around the Supreme Court actual malice requirement and allows public figure plaintiffs to unmask anonymous critics with little regard for the strength of their underlying libel claim. As a result, the Ottinger court handed over the identities of anonymous posters without considering that the John Doe's identity alone is all a public figure libel plaintiff needs to launch a campaign of intimidation, harassment to silence what might otherwise be a lawful criticism. The result plainly contradicts the spirit of the Supreme Court precedent that affords greater weight to anonymous free speech than to a public figure's right to recover for defamation. In Ottinger, the parties did not dispute that Mr. Ottinger, as a former congressman and law school dean, was a public figure who would be subject to establishing actual malice before prevailing on his libel claim. Nor did the parties dispute that the anonymous blog posts at issue identified the plaintiffs were effectively published by their posting on the internet, were of a nature that charged the plaintiff with a crime, thus failing under the category of libel per se and removing the necessity that plaintiff prove injury. Rather, the disputed issue countered on whether it was appropriate to require a public figure libel plaintiff to make a prima facie showing of actual malice at which an early stage litigation. The Ottoman court ruled incorrectly on this issue, finding that the actual malice standard should not be added to the dendrite test. So, man, maybe this was a bad idea to read it, right? Maybe I could have just summarized it for you, but it was actually kind of hard to summarize. It actually gets a little bit worse for the blogger here, right? But it also gets a lot worse for Mr. Garcia trying to use this court case to prove defamation and libel. And we only have about 2 more pages to cover. For public figure libel plaintiffs seeking only to harass and intimidate their anonymous critics, unmasking their critic identities may be the only judicial remedy they really care about. Whether their defamation claim is actually valid makes no difference to the plaintiff, for the lawsuit is only one tool in a concerned public relations campaign to silence critics. Recognizing that public officers should receive less protection from libel than private citizens, the actual malice standard is an important shield of anonymity posters facing intimidation suits by public figures. When dealing with libel claims brought by public figures against anonymous internet posters, it may also be true that courts will rarely reach the actual malice analysis because a libel claim can only go forward if the material alleged to be defamatory is a statement of fact. Given a growing line of cases, including Cahill, which have found that reasonable readers do not presume postings on blogs and message boards to be factual, it is hard to imagine how the allegedly defamatory statements at the issue in Ottinger could withstand the motion for summary judgment on the statement of fact element. It is even harder to imagine the same statements meaning the egregious nature standard proposed Sapra as a substitute for direct evidence of actual malice. So where is all of this going? The Cahill decision quashed the plaintiff's subpoena on the grounds that the statement alleged to be libel were in a context so unreliable that they could not be read as factual and thus not defamatory. Further, the Cahill decision noted that blogs and chat rooms tend to be vehicles for the expression of opinion. By their very nature, they are not a source of facts or data upon which a reasonable person would rely. The statements at issue in Ottinger, in their entirety and grouped with the non-offending statements on Luhad blog, display many hallmarks of unreliability that Cahill and other courts have identified in order to question whether reasonable readers would believe what they read on a particular message board to be factual. These posts are rife with hyperbole, grammatical errors, and irregular use of capitalization to connote emphasis and sarcasm. Last page, I think, almost. Moreover, several of the statements at issue in their unbridged form contain descriptions of personal observations from which the anonymous poster appears to draw their conclusion. Courts have long held that these types of statements are presumptively non-defamatory because a reader can judge the quality of a poster's analysis himself and is thus more likely to recognize that the poster's comments are subjective opinion rather than objective statements of fact. Although the Ottinger court made a strong move toward adequately protecting anonymous online speech by adopting the standard of dendrite, it took a step backwards by adding the caveat from Cahill that a public figure's libel plaintiff does not have to show any evidence of actual malice. Furthermore, the Ottinger court application of the dendrite test failed to discuss the unreliable context of the Luhad blog postings in its determination of whether the postings at issue were capable of conveying defamatory meaning. The Ottinger court allowed public figures to bypass the significantly higher burden of proof normally required for public figure libel plaintiff, both by adopting a weaker than necessary standard and then by failing to properly apply it. Therefore, it allowed easier access to the identities of anonymous posters, which is a powerful remedy in itself for libel plaintiff whose only interest may be in pursuing an extrajudicial remedy of intimidation. Indeed, the Ottinger libel claim was eventually thrown out because it could not meet the higher burden of proof normally demanded of public figures libel plaintiffs, but not before the Ottingers were able to find out their neighbors were behind the original posts. As more libel cases are filed against anonymous posters, further application of the Ottinger test may convince John Doe that it is safer to log off the internet than to mouth off about public figures, a result that contravenes the First Amendment and chills the anonymous speaker's right to free speech. All right. All right, guys. I know that was a lot. And I somewhat apologize about that. I think I lost about 300 viewers reading that. I know it's not important to you, but it was important to me. And the reason why it was important to me is because I am a YouTuber. And as a YouTuber, I also like to know my rights, and lawyers are expensive. And so I've been reading about rights over the last 48 hours. And this one is pretty damn simple, okay? Calling something a scam is a matter of opinion. It's not a fact, okay? Now, calling something a scam as a matter of opinion that relies on facts is perfectly fine. Now, if those facts are found to be incorrect, then the person posting the incorrect facts could be potentially in trouble. But this is going to be interesting, right? So this is my YouTube view on the situation of getting a cease and desist and accusation of defamation and libel and causing harm to TokenPay. I will also add that the only people that take legal action for this stuff are generally of scammy nature. Once again, opinion from what we've seen in the past in the crypto space. All right, I believe that is it. I believe that's all I have to say on the matter, though I will do one more screen share. And just to give you a few more references really quick, I'm not going to read them. I already put you guys through enough. But if I go back to this, right here is the court case of Mccabe versus Rutner. This was the case I suggested that people look, and this is the case that basically states that using the word scam as an opinion is not a fact. It's an opinion, and therefore will not qualify in a defamation case. So please check this out. This was actually another amazing read. Now, in case I totally screwed this up, but you enjoyed this episode, I created an address which will become a multi-sig. Currently, it's just I didn't have time. And this is going to go solely to the tone-based legal fund, because I'm pretty sure this is not the first, well, this is the first, but it won't be the last legal action taken against Tone. Now, you don't have to donate, but if you'd like, there it is for you. Maybe I'll tweet it out. We will see. But hope you enjoyed this episode of CryptoScam. Why isn't this going away? There it is. Okay. Now, it will be interesting how much worse of a legal situation this creates, but I cannot stand by and allow, something like a lawyer sending me a plagiarized letter looking to sue me and not do anything about it as a podcast creator. Okay. So please support, please share, please be aware of the practices of these ICOs. Okay, please. I'm going to stop the screen share. It's already getting dark. And thank you so much for sticking around for another episode of CryptoScam. Usually they're pre-recorded and they're usually with guests. But, maybe I'll keep the series going. Unconfiscatable. All right. Applies to me as well. All right. Thank you so much. And I will see you all on the next episode of CryptoScam.